You've found your dream house. It's for sale through probate with court confirmation. When a probate sale requires court confirmation, the timing and amount of your offer and the form in which you make your deposit are closely regulated. This is a legal proceeding described in the probate code, which may vary from state to state. Briefly, here's how it works. The property is listed for sale. Potential buyers make initial offers or bids on the property. An initial bid is accepted along with a 10% deposit. The attorney for the estate then petitions the court, and a date is set for the court hearing to confirm the sale. The realtor continues to market the property, seeking an overbid that will earn more money for the estate. Overbidders are invited to compete for the property at the court hearing. They must bid additional sums in increments specified by the court. The minimum first overbid price is set by a statute in the probate code. In California, this is the amount of the accepted offer plus 10% of the first $10,000 plus 5% of the balance. Here's an example of how the court calculates the minimum overbid. A property is listed at $200,000. The accepted offer is $175,000. Add 10% of the first $10,000 or $1,000. Add 5% of the balance are $8,250. The sum is the first minimum overbid amount, or $184,250. For the probate attorney in the court to allow you to overbid on the property, you must have in hand a cashier's check for at least 10% of the opening bid. Personal checks are not accepted. So in our example, 10% of $184,250 is the amount of the cashier's check. Before you come to court, the listing agent can advise you whether to make the cashier's check payable to the estate, the trust, or the conservatorship. Depending on the property and the price, there may be no overbidders, or there may be one of several competing with each other. Many overbidders come to court unprepared. They expect to be able to negotiate. They don't have the payment in the specified form made out to the correct payee, or they are not prepared financially to raise their bid, even though they really want the property. To overbid for real property in a probate court hearing, both the buyer and the buyer's agent must be present. Read the disclosures. There are special disclosure documents governing probate sales, so be sure you understand the terms before you make an offer. If you are the successful buyer, you will purchase the property under the same terms and conditions as the party who made the original offer. Unlike other real estate transactions, you cannot ask for different terms in the hope of improving your chances of getting the property. Read and review the instructions before you come to court. Terms are not negotiable. Ask questions. There are usually no contingencies on probate sales. In other words, the seller does not have to wait for you to find a loan or to sell your existing home. Get advance approval from your lender. Know your top dollar and at what price you're going to walk away from the property. Don't get caught up in the competition of bidding. While any agent can represent you, only a probate expert can assure you that your transaction is managed correctly, so you get the property you want. If you are unfamiliar with probate court proceedings, if you have any doubts about how to present your offer, or if you just want to hear it all again, call the Sanborn Team. The Sanborn Team. No excuses, just great service.